Okay. Uh, Good morning, everybody. I'd really like to thank all the participants in today's webinar. We hope to have a very interesting discussion with our esteemed panelists today, and we are going to touch upon some of the pain points our industry faces and what are their experiences, their feedback, given the long 3 odd decades of work that they have done in our fraternity. Um, I will take the lead in introducing Mr. Vishal Sheth. Uh, Mr. Vishal Sheth is a lawyer by profession. He graduated from the Government Law College, Mumbai in 2001. Since then, he has been associated with the chambers of George A. Rubello and has been practicing before courts in India and international arbitral tribunals. His practice covers general commercial law with a focus on commodity, international trade disputes, shipping, that is wet and dry, and the logistics. We hope to get a lot of feedback from him. Over to you, Amit.
Welcome everybody. My name is Amit Bendre, and I am very glad to welcome our President of AMTOI, who needs no introduction. He is also Mr. Badkamkar, Shantanu Badkamkar ji is also a member on the Court of Indian Maritime University and National Shipping Board. And with his vast experience in shipping for decades, he is going to give us a lot of inputs on this particular topic. As well, we have Mr. Makarand Pradhan, who is the President of Consolidators Association of India. He too needs no introduction with his maybe 4 decades of experience in consolidation world over. He is going to throw a lot of light on this critical issue of claims that we all face as members of CAI as well as AMTOI. Keur, to you to introduce Mr. Jagannathan from our guest speaker.
Sorry, Amit. Can you just do that? 1 second.
Okay. So I would love to introduce Mr. Jagannathan, who has always been very helpful to AMTOI and CAI to, give us his inputs on many issues. The last webinar we had was on bill of lading, where he was the guest speaker, and it was a very well accepted, webinar. So Mr. Jagannathan has more than 25 years of experience in various facets of shipping and international trade. He is the founder of consultancy firm that handles various marine related claims. Jagan is a panel arbitrator at various institutions, including the Singapore Chamber of Maritime Arbitration, China Maritime Arbitration Commission, then Emirates Maritime Arbitration Center, Asian International Arbitration Center, and the Indian Council of Arbitration. He frequently lectures on shipping, marine insurance, and related matters at various forums. In his free time, he writes regularly on transport and marine insurance, dispute resolution, and related matters. So I welcome all of you all, and I hand it over to Mr. Jagan to take it forward. Thank you.
Mr. Jagan, you're on mute.
You're on mute.
Amit, can you unmute him?
Yeah, hi. I think I've now got the control of the mic. Thank you. First of all, good morning to all from India. Good afternoon from other parts of the world. Firstly, I must thank AMTOI and Consolidators Association of India for organizing this webinar and inviting me to participate. Thank you very much. I understand that the intention of this webinar is to have a discussion on the various claims which an operator may face, either as a multimodal operator, or as a consolidator, or as a freight forwarder. So before we have the joint discussions, I thought I'd discuss the application of a transport liability policy, and which provides cover to an operator who may be any of these parties, that is a freight forwarder, say as an agent, freight forwarder as a carrier, a contractual carrier, in which case he becomes a carrier, which means he may be a multimodal operator or only be involved in the ocean carriage, etc. I must give the usual caveat that should you face any actual issues, you must seek advice from your brokers, your insurers and lawyers like Mr. Sheth would be more than happy to help you, guide you. So, the reason why I say it is the world has become, from complicated, it has become complex. There is no right answer or wrong answer. It all depends on various circumstances. So, professional people would be able to guide you depending on the circumstances, how to deal with it. So our topic is just going to touch on these aspects, but it doesn't mean that is the only answer. It could all depend on many factors, which is there. I'll just share my screen. Give me a second. Okay, I've got my presentation on, so I think you all can see the screen. So moving on, if you really look at it, I assume that most of you are because you're acting as a transport operator, you would be actually ensuring your liabilities for your arising from your role as a transport operator, be it a freight forwarder, a consolidator, or a multimodal operator. A transport liability policy generally provides cover for various risks arising out of the roles, arising out of the role as an operator. The heads of cover included in the policy is cargo. There is a difference, when I talk about cargo, it is not for the cargo value. There is a difference in what cover is provided in the transport liability policy. I make this distinction at the outset, given that insurance policies taken by cargo interests is generally for the full value of the cargo. However, if you are a transport operator, you and your insurers will rarely, if ever, be aware of the full value of the cargo. Instead, the cover is for the liability which may arise due to the loss of or damage to the cargo whilst under your care and custody. I must also like to point out, which I'll probably touch on it a bit later, your insurers will, as a requirement of giving cover, will require that you as a transport operator contract on the basis of standard trading conditions which are seen and approved or deemed approved. What do I mean by deemed approved? I mean, in instances of standard trading conditions promulgated by national freight forwarding associations, say for instance, FFFAI, these would be deemed approved and therefore they do not need to be vetted by the insurers. Or, if you don't have standard trading conditions or under compulsorily applicable cargo conventions, laws such as the Hague-Visby rules or the Multimodal Transport of Goods Act 1993. So what it does is, you are able to ascertain what is your exposure in your role as an operator. And when it also allows an operator to exclude liability in some circumstances, and in cases when he is not able to exclude liability, he or she is entitled to limit liability. The fact is, a carrier will rarely, if ever, be liable for the full value of the cargo, especially for high value cargoes, given that the limitation of liability would in any event provide some defense insofar as the exposures are concerned. So that is the reason why, even if you have a transport liability policy, if you have a carrier having a liability policy, you need to know there's going to be a gap between the cargo value and the exposures. So the cargo interest should always be encouraged to take a cargo policy. I know in the real world, people try to scrounge, don't want to take it, but this policy is not meant to cover the full value of the cargo. I would also like to emphasize that, some policies require that, the insurance cover is only provided subject to the insured contracting on the basis of STC, etc. So if you do not do it, you may prejudice the cover. So that's the cargo cover, so to say. The next cover is the errors and omission. This has to be due to some error or omission of the insured, such as release of cargo without the original bills of lading, leading to a claim being made by the insured's customer. You have to understand that policies are meant to cover only a risk, not a fortuity, not to something which is certain, not a certainty. So in these type of losses, the burden of proof is on the insured to prove that this was a fortuitous incident. It happened by chance. It was not something which was waiting to happen. The burden of proof being on the insured. The next type of cover is third-party liability. If you're the simplest example I would probably give, because I see consolidators also are participating in this event, is if there is a DG cargo in the container and due to which this cargo creates fire and this fire spreads in a hold of a vessel. The other containers on the hold of the vessel are not having any contractual relationship with the operator. So they are third parties, so to say, and they would be entitled to claim because the fire was caused by the cargo inside the container. So this cover is basically to deal with third-party exposures. Although, in my view, this I think is the most important cover provided by transport liability policies, because in this case, you would not be able to exclude or limit liability, which you have contractually available when you're doing it with your counterparties. The next is fines and penalties. In the case, if a transport operator is fined by a specific port authority, as long as it is not against the law, there is cover available to deal with these fines and penalties. Generally, the limit under this policy is not substantial because fines and penalties are aimed to penalize someone. It is for a much more limit, but yes, cover is there. And the last part is on costs. You may incur costs to defend the matter. And if, as long as the claim falls in one of the heads of cover, which is covered under your policy, the costs incurred will fall under the limit of the policy. A subsidiary cover, which is also given in the cost, is uncleared cargo. Suppose a consignee does not clear the cargo at destination. Yes, this is a risk which insurers are not very comfortable, and that is the reason they put a very low limit. That is costs which are incurred to try and get the cargo out, but this needs to be done promptly. So you have this covers which is there. There are some extensions. I have not actually put it, but you have extensions. If you are a container operator, you can take extension for equipment. You can take for, if you feel that your counterparty, your clients are constantly fighting, you may like to take legal disputes covers known as FD&D cover. So these are extensions which is commonly available. But if you look at the heads of cover, I think these are the 5 covers which you will generally find in a policy. When you have a loss, you would first look at whether the insured, which is an operator, has he a liability or not. Again, I must say that it's a fine art because both parties may tend to disagree, but it has to be decided by someone else. If your contract provides for arbitration, it will be decided by an arbitration panel. If it provides for the jurisdiction of a specific court, or the courts of some jurisdiction decide they are entitled to deal with that matter, they will then decide whether you're liable or not. So although the insured may have a perfect defense, he or she would need to attempt to defend it. Otherwise, if he doesn't participate, you may get a default judgment. So, I make with this caveat that insured's liability is something which could develop depending on the circumstances. If there is a certain that you have a potential liability or liability, then you would look at your policy if you have a transport liability policy. And that is when you will have adjusters to look at it to see whether the risk or the loss falls under the cover provided in the policy. Invariably, transport liability policies are on named peril basis, which means that the loss needs to fall under one of the perils mentioned in the policy. There are many types of policies like all risk. If you look at the cargo, you've got ICC Institute Cargo Clauses A, which is an all risk policy. But if you look at other types of policy, they are basically on named perils. And then you look at triggers. There are basically 2 common triggers: loss occurrence and claims made. Loss occurrence means the loss needs to occur during the period of the policy. Claims made means the claim must be made during the period when the policy, the policy is in place. I think which is better and all, you need to discuss with your brokers. There are distinct advantages and disadvantages of each type of policy. But you will generally find that even in one policy, you may have a combination of both these triggers, especially for errors and omission. They are generally on claims made basis. Claims made basis would also have a retroactive date so that it does not take claims before the policy period. So it is not so simple. You need an expert to guide you on how it is done. And I, the last thing which I wanted to touch is basically, when you look at a loss occurrence or claims made basis, how do you decide the policy engages or not? You'd probably look at the doctrine of proximate cause. I am more well-read as far as the English law is concerned, but I understand that the Indian Marine Insurance Act 1963 is particularly similar. Is Section 55(1), which talks about proximate cause. And what would happen is, like we talked about, a named perils, you need to find one of the perils which is mentioned in the policy, if it is on a named peril basis, to find if cover is there or not. What happens if there are multiple perils, which deal with a loss at the same time? You would need to look at whether the perils are explicitly excluded, covered, or not covered. As long as the combination does not include an excluded part, and there is one combination includes an expressly covered part, the cover is in place. So if you have a loss which is not expressly covered, then you don't have cover. If it is excluded, exclusions always override any positive cover. So if there is any exclusion in the policy, we don't cover, it will not cover. Once there is cover, then you probably look at the policy limit, like I said, you need to ascertain what is the exposure. And for the policy limit, after the policy limit, you look at your deductible and excess. The gap between the policy limit and the deductible and exposure or excess is what the insurers will pay. This, in a nutshell, is what the policy is. In a nutshell, is how a policy works in the transport liability field. I don't have anything else to say. Thank you for giving me an opportunity to just go through this thing. I now hand over the mic, so to say, to Keyur and Amit.
Thank you, Mr. Jagannath, and for the very brief introduction in terms of the kind of insurance coverage that is available and what people should look at when they're looking at an insurance policy. I will now start with a few set of questions that we have compiled amongst ourselves, based on which we will keep the floor open for the panel for a healthy debate and a healthy discussion, only to enlighten all the attendees. So as mentioned before, this is a joint webinar between AMTOI and CAI. The first case study that we have brought is put on the screen. I'll quickly read it out for all. The consolidator gets into a contract with an Indian importer for import freight. Bill of lading issued to the shipper is issued by the origin agent. Upon arrival of the cargo, it is overturned as damaged. Indian importer holds the Indian consolidator responsible for the loss. Indian consolidator is unable to pass on the claim to his origin agent, as the Indian consolidator is unable to prove that the damage occurred when goods were in custody of the origin agent, or maybe the originator agent refuses to cooperate. The Indian consolidator has to face the financial consequences of the claim, since he entered into a contract with the Indian importer. The questions are, what protections are available to the Indian consolidator, and is it advisable in such situations for Indian consolidator to instruct the origin agent to issue the consolidator's bill of lading under Indian COGSA so that he is eligible for protections and indemnities under the Act?
Okay, I'm happy to take this question if it's okay with you all. I think, if you really look at it, you have to first ascertain what is the contractual position between the Indian consolidator. By definition, because he doesn't consolidate himself, the consolidation is being done at origin port. I would assume he's acting as an agent of the cargo interest, the consignee. So if he has a STC, incorporation of a standard trading condition or some sort of a terms of engagement, he would be able to show that he was only acting as a facilitator, an agent. And in the and therefore, he should be able to defend or deny his liability. I am aware that in most of the cases, parties do not have any proper terms of engagement, and that is where you have a gray area, wherein you need to show that, you need to show that, yes, you have some sort of you're only facilitating it. There is a bill of lading which is actually shown to the shipper. The bill of lading is transferred. It comes to either the banking chain or somewhere else. And if you could prove it, but then, it makes it more messy. The easier way is to, if you are contracting on the basis of some terms of engagement, which clearly lays out what your role, your duties are, it is much more better. Now, insofar as the damage happened, you said you're not able to find out where it is. When the cargo is being delivered, if it is delivered and damaged, yes, the inference would be that the loss or damage occurred whilst under the care and custody of the carrier. So I assume that the cargo was damaged during the transit. So when you're getting delivery, someone would give a dirty a receipt or an unclean receipt, so to say, saying, listen, I got damaged goods. That is more than enough. Now, in right circumstances, the consignee should go directly after the BL carrier. He should, whichever, he should try and go to the Indian courts or whichever is the jurisdiction clause, that's his ambit to decide. If he has the cargo policy, the right way is to actually try and enforce his cargo policy, get his claim paid by his cargo insurers, and then let his cargo insurers go after the actual carrier or the consolidator by way of subrogation. So I think as far as an Indian consolidator is concerned, if he is not consolidating, if he is only facilitating it, it would be worthwhile to work on the basis of some sorts of terms of engagement so that parties are aware. I think I've told earlier also that these STCs not only help in dealing with these recoveries, but also have other provisions which are very helpful. I don't think it is worthwhile to ask your agent or your origin agent to use your own bills of lading. The reason being is Indian COGSA applies only for outward shipment. If you look at the Hague-Visby rules, India is not exactly a signatory. It was at the time when India got independence, we were a part of before the independence, we were following the UK laws. To my knowledge, I don't believe they are a signatory, but they have implemented Carriage of Goods by Sea Act. I think, I forget the year, which is similar to the Hague-Visby rules. The way the Hague-Visby rules work is for outward shipment, not inward shipment. So the right way is, if you have a shipment from China, it should be the Maritime Code of China. If you have the Taiwan, it should be their code, because that is the outward one. And I think the most important one is the agent should also have proper liability insurance, wherein he should also cover his role as an agent. He should tell his insurer that he is doing shipments as an agent. That, I think, is to sum up what I would like to say. I'd be happy to hear from other members of the panel.
Can we have Mr. Makarand also share his inputs, followed by Mr. Shantanu, and then we can recap all the points with Mr. Vishal. Mr. Makarand, you're on mute. Sorry, Mr. Makarand, you are on mute. You'll have to unmute. Sorry, Mr. Makarand, can you unmute? Okay, Mr. Shantanu.
Okay, I'll start. Fine. I think here there is a situation where two possible interpretations can be given equal weightage. One is the contract of carriage, which is the bill of lading in this case, is issued by the origin agent. So essentially,
Okay, Mr. Makarand, sorry.
Makarand, you want to go ahead? Please go ahead.
No, you can go ahead. I can then say, because the host had put me on mute, so I could not speak.
Okay, so I'll continue. Okay. See, here we have two possible interpretations and both are equally strong. One is the bill of lading is issued at the origin by the origin forwarder. So actually calling him as agent also is misleading. We have to define relationships among the two parties, which is two forwarders, about who is agent and who is the principal. That is also equally important between the two parties. So when we agree that the origin has issued bill of lading to the shipper, the contract of carriage is between the shipper and the origin forwarder, and by assignment of contract, it comes to the consignee. So essentially, I can see that the origin forwarder cannot claim immunity from his responsibility. On the other hand, for Indian forwarder, the Indian consolidator or the destination agent of the origin forwarder who has done sales to him is the person available, and it is very normal that the claim will be filed on a local party. In addition, if the sale is done in India and quotations are given in India, we have cases where these quotations are considered contract of carriage. But I would still like to point out, while it is being considered as a contract of carriage, and that's why it's a contract between the importer and the destination agent, the fact is when the importer gives nomination to the shipper, he gives name of the origin forwarder as his bill of lading is acceptable, be it as a routing order or be it as a nomination in letter of credit. So considering the weightage of both, in my opinion, the primary liability will be of the origin forwarder, irrespective whether we are able to establish where the claim or loss has occurred or not. Wherever it may have occurred, the contract of carriage is between the shipper and the origin agent. So this is my analysis of the situation. Makaran?
Can I say? Okay.
Yeah.
See, whatever you have said and Mr. Jagannath Muttu has said, these are, the legal aspects of it. But what happens in this case, majority of the times, is these type of claims are settled on the basis of commercial call taken. Okay. However, I would put it on how we are taking care of such type of claims for the shipments which we are effecting. We do effect a lot of shipments coming in from various origins. Firstly, all our contracts are with our agents are very clear that whether whoever issues the BL, if we are providing the outturn report and the photographs at the time of destuffing, the status of the cargo will determine who is responsible for it, and he jolly well takes the responsibility. And we have been successful in taking care of claims. We don't have problems with our agents in this regard. All our agents and partners have been very, very cooperative on this. At the same time, whenever we are accepting bookings from any forward, it can be a forwarder or it can be a direct consignee. Majority of the times it is it's a forwarder and not a direct consignee who deals with us, because we don't market to the direct consignees majorly. But we are making it very clear with our customers that should there be any claim, it has to be fought between the cargo carrier and the consignee or the person who is insuring it. The insurance that we have is to protect us from the liabilities, and it does not cover the cargo value. So if we are clear about it at the contracting stage, then a lot of issues are taken care of, and then you can avoid these type of situations. But having said that, whatever precautions we take, it is final. So,
Sorry.
so the values are less, and we have been taking commercial calls on it to settle the claims. Thank you.
If I may just add to what has gone before me, uh, typically these cases of cargo damage will fall under two categories. Now, the consensus that yes, the consignee is entitled to move against the issuer of the bill of lading is absolutely correct. Because as far as the consignee is concerned, he has received the damaged cargo under the bills of lading, so he will sue whoever has issued the bills of lading. He's not really concerned of the arrangement between the load port consolidator and the discharge port consolidator. But importantly, in the case of FCLs, when they are stuffed and sealed by the shipper, in that case, all FCLs contain an endorsement saying that the carrier does not warrant the condition of the cargo. So in those cases, really, it is then for the consignee to prove that the cargo was loaded in a sound condition and that the damage due. It is typically a defense in which the line will take up in case of shipper stuffed FCLs, because the line will then have no idea about the condition of the cargo when it was stuffed in a container. So that is typically a defense we see coming up in legal proceedings, where the line says, look here, it was an FCL shipper stuff. So there's nothing to suggest that the cargo was loaded in sound condition. So that's another legal practical aspect of such claims.
Great. Mr. Jagan, would you have any additional inputs on what has been said so far? Or can we move to the next case study?
Yeah, please move to the next. I think what my colleagues have said, it's all correct for this thing. But yes, I think we have covered this in this thing. Let's move to the next.
Okay. So this is the second case study. The forwarder has quoted for movement of perishable cargo in reefer containers. The scope of service includes stuffing at the CFS, customs clearance, and ocean freight. The quotation is confirmed by the shipper, and hence the contract between shipper and forwarder is established. The shipper gives explicit instructions on maintenance of temperature and humidity of the container. The forwarder in turn gives explicit instructions to the shipping line and the CFS. Cargo stuffed in the CFS selected and hired by the forwarder. So here the forwarder is choosing the CFS. Cargo is moved under the bill of lading of another NVOCC. Cargo is found dead or damaged upon reaching at destination. Now, herein the shipper holds a forwarder responsible for the damage to the cargo, stating that the contract was between the shipper and forwarder. The question is, since there was no bill of lading issued by the forwarder, no clause of limitation of liability is applicable. Can the terms and conditions of FFAI apply? The quote of the forwarder did not mention of such standard trading conditions. However, the footer of the email clearly states that all business is undertaken under the FFAI standard terms and conditions. Can I request Mr. Vishal to quickly give his inputs, followed by Mr. Jagan?
So this is usually always problematic where you don't have a firm quotation and an approval or a firm mention or a reference to standard terms and conditions. Now, as far as the law goes, it is really a mixed bag when it comes to these fine print clauses. So merely because your email has a footer in fine print saying all business is carried on as per these terms and conditions does not in fact in all cases make those terms and conditions applicable to the business. Because some courts have taken the view is that, look here, having this fine print clause is not enough. You have to specifically invite the other party's attention to that clause, saying, I am carrying on business as per these terms and conditions. Please be aware of that. So it will really be fact specific, but the mere fact that your footer of an email does not has a reference to these terms and conditions may not make them applicable. And it's always prudent to therefore have either a standard term and condition or a firm quotation which lists out certain fundamental terms and conditions if you are looking to protect yourself. That's what I keep advising clients.
Sorry, Mr. Vishal, just to add on to that, as forwarders, many a times we tend to give quotations even on email. and it's not in a separate document or a PDF or such format. The
Sure.
email body itself is the quotation. And
Sure.
if the email footer does contain the clause on the standard term trading conditions, would it therefore be deemed that the reference to the STC so given is applicable for that specific quotation?
Well, I wish I could give a clear answer to that, but I can't, because the court will look at things as how big was the disclaimer at the bottom, where is it mentioned in the email. So what I would advise you to do is, instead of having it merely as a footer, you just add another condition to your, in the body of the email, saying take note that all business is carried on as per these terms and conditions. That would probably be the more prudent way of going about it, because you never know how courts view these things. There are cases when they say they are applicable. There are other cases when courts hold that such fine print clauses are not applicable unless they've been specifically invited to the other side's attention.
Okay, so the bottom line would be that just having it on the footer and us assuming that this would be applicable or in our protection is not the right assumption to make. Am I correct?
It's not in all cases.
Okay. Over to you, Mr. Jagan.
Okay, like Mr. Vishal says, it all depends on different circumstances and the location where the courts are. In other jurisdictions like Singapore or UK, a footer would do. But the most critical point is proper incorporation in the contract. What a court would probably look at, was the standard trading conditions made known at the time of quotation, or was it afterwards? Now, yes, it would be more prudent to try and show it in the court. Listen, we contract on terms and conditions which exclude or something. Then it is much better than to go around this thing. So, as I see it, there are two issues in it. One, you as a forwarder, you're given a quote to your shipper that you are trying to give a freight, a reefer freight, and which has got damaged. A forwarder by definition is an agent. Yes, you have done your bit by trying to quote. In the circumstances which you have mentioned below, it does appear, it has been notified to the client that, listen, I contract on terms and conditions. So insofar as if a person wants to go and claim from his insurer, I think I would assume that insurers will consider it favorably that they have done their duty. The policy would be triggered to deal with it, provided you have a policy which has declared what type of business you're doing. A liability policy should to deal with it. Now, going by other thing is, if you are acting as a forwarder or a carrier, there has to be some sort of a negligence to go after you. You have not issued a bill of lading. You have done your freight contract. You have provided the bill of lading. If no one proves that you have given the wrong temperature instructions, if the instructions of wrong temperatures on the carrier, it's a question of directing the shipper to go and claim from the actual carrier or the NVOCC who may be at fault. In the event the shipper is not willing to do it and he wants to pursue you, I think one of the ways is to also join the carrier, saying that I am not responsible, but if and the carrier is responsible, alternately I have a right of indemnity. I think that is one way of doing it. Or the alternate way is to assign your rights. The bill of lading has not been issued to the forwarder, so there is no rights to assign also. And I think that is the way I would probably go about it. I know perishable cargoes can be messy. Sometimes if it is especially frozen cargo, it can be for high value. And I have seen cargoes, spoiled because of incorrect temperature, this thing. But I think in this way, this is how I would deal with it. Like I said, there is no right or wrong answer. It all depends on different circumstances. Thank you.
Thank you. Mr. Makrand, would you like to share something? Sorry, Mr. Makrand, you're on mute. Sorry, Mr. Makrand, you're on mute.
Yeah. I haven't come across such type of a case, but I will give a different kind of thing, because if a shipper can hold me responsible without issuing a BL, wherein the BL is an explicit contract between the shipper and the consignee when the shipper accepts the bill of lading. Okay, I think this should supersede all the other contracts earlier made in this particular case. And in that case, I would go on to file a claim with a carrier, or I will ask my legal team to file, because I'm 100% sure I will not lose from both the sides. If I lose from one side, I win from another side, and that would cover my losses. I have a similar case wherein one of our container was not taken delivery for a long while in Brazil, and then the Brazilian authorities, they ordered to check the inside of the container because it was stinking. The consignee saw that the cargo, what he had ordered, was not of the same quality or as this. The shipper claimed on us why we have allowed to inspect the cargo, whereas we had all the proofs that it was ordered by the Brazilian Ministry of something, textile or something. And then the line claimed on us for the detention because we were the booking party. What we did was we filed a case against the carrier. So here we had an insurance. If we lose with the line, we will win with the shipper, because it is the same scenario. Because on the lines BL, I was I was the shipper. So this is the way I would balance my thing, and this was told to me by our insurance company, and it went on successfully. So I can say that this is the way I would look at a situation like this. I do not know whether it is right or wrong, but the result has been in our favor, that we were absolved of the claim from the shippers, and having lost this thing with the carrier, we asked the carrier, because the actual shipper is the one who is the owner of the cargo, and we could pass on the detention amount also to the shipper. So that is how we had managed it in that particular case. Thanks.
Sorry, again, this is a question for the three panelists. Now, in this particular case study, the key factor is that the stuffing was done in a container freight station, and this CFS was chosen by the forwarder. As far as the mainline carrier is concerned, it is still a set shipper's loads to and count container. And therefore, I would assume that the carrier is completely absolved from all responsibilities and liabilities if proven otherwise. But the fact that the CFS is chosen by the forwarder, what are the possibilities of putting a claim on the CFS? And what are the liabilities a forwarder would face? With the shipper will obviously come on to the forwarder for having chosen the CFS. That's a leading question that I had. I would like to start with Mr. Shantanu if he has any inputs. Otherwise, we can move to Vishal to give his inputs on this question. Yes, Mr. Shantanu, you're on mute, Mr. Shantanu. Amit, can you unmute Mr. Shantanu?
Yeah, host has to allow me to unmute. Okay. See, this case raises several issues. In fact, not one issue, several issues. One is our right of recourse on the CFS and the NVOCC. Now, that is also a suspect, because the interested party, the shipper on the bill of lading, is the actual shipper. So we are in a situation over here where our rights of recourse on the CFS and the NVOCC is suspected, because it is actually in the name of original shipper. Now, why has the shipper preferred to proceed with the case with the custom broker or forwarder? It is because the bill of lading conditions have specific limitations of liability. Now, since the cargo value is quite high, the shipper is relying on the quotation given on email to be the base as a contract of carriage or any contract. Now this, I still feel, is an unsettled case about who should be treated as a carrier. Personally, I share the view given by Makran on this. Is once the shipper accepts a bill of lading issued by NVOCC, it is his acceptance that he has not entrusted cargo to us as a carrier, but only as his agent and as an organizer. And so long as the AAFI standard trading conditions show, the custom broker or freight forwarder has exercised adequate diligence in selection of a proper NVOCC and a proper container freight station, they should not have a liability because they have selected the vendors diligently. Equally, while the shipper may treat this quotation as a carrier, nowhere the quotation says that the forwarder or custom broker is putting as a carrier or accepting the contract as a carrier. So I still feel it will be a gray area in two circumstances. One is whether this is really a contract of carriage which shipper can hold, provided the forwarder custom broker is established that there was no negligence on his part. Two, when it comes to right of recourse, whether the forwarder will have any recourse on the CFS and on the NVOCC, which in this case is a shipping line, we can say, because NVOCC and shipping lines don't play a different role insofar as contract is concerned. So I believe these are some open areas where we should have clarity, and as Vishal pointed out, we have to be more explicit in the contract about this is a quotation where we are not a carrier. Nonetheless, there are jurisdictions where such footnotes have been held valid. There are where it has not been held valid, particularly in cases where the shipper is not a regular shipper. If a shipper, for example, is a individual shipping personal effects, he is not expected to know the nuances of the trade. On the other hand, when shipper is a regular exporter, he is expected to know all the nuances of the trade, and he is also expected to know what is the role of a custom broker, freight forwarder, booking agent, actual carrier, a freight station, and who is liable for what. So my personal emphasis will be on latter part. When a regular exporter does this, he is expected to know the difference between different service providers. That's my take on this issue.
Noor, I would like to come in here. As a freight forwarder who has done the CFS stuffing of refrigerated cargo, like Mr. Jagan said, in the liability insurance, limited liability insurance cover that the freight forwarder would take, he can include certain aspects to that insurance. Mr. Jagan, am I right? That's what you said.
Well, I'll put it this way, when you're a freight forwarder, yes, you can take extensions, but in this case, there's no extension because you're not taking cover for cargo. You're still doing your job as a freight forwarder, as agents in this case, because you're not issuing a bill of lading. So, there has to be some sort of negligence, but the policy would engage to deal with it. As I said, if is there insured's liability or not? The liability is determined by the judge or an arbitrator. So till that time, the policy would engage to defend the claim. So if the shipper wants to pursue a claim against the forwarder, and there is no fault on the part of the forwarder, and the shipper doesn't want to listen, and he goes to whoever he wants to go to sue, the policy would engage to deal with it. And the policy would defend it, deny it, and if there is any claim, it would try to also recover from the actual carrier. So the liability policy is basically as a defense and attack policy, so to say. It is not meant to pay the claim by itself. It is meant to, that's the way it functions. It is basically, it works on that function. Now, since KU asked, before Vishal goes this thing, KU asked a question is what happens if the container, the CFS is selected by the forwarder, the CFS is selected. Now, in this case, this is actually a reefer container. The controls of the reefer container are done by the carrier. It is not done by the CFS. Even if it is done by the CFS, when it is gated in the terminal, I come from the shipping background. Before I started this career, I worked for different shipping lines, agencies, so I know how it works. So when it is gated in, the temperature is checked. The bill of lading will mention the temperature at the time of loading. So you need to start looking at from that perspective. When it was gated in, was the inspection done? Was the set temperature the correct set temperature? I don't think, unless you can find some fault on the CFS, that they have not stored the cargo properly. If you look at reefer cargoes, the air has to pass. The vents need not be blocked, should not be blocked. There is a right way of doing it. So if you can find some negligence, yes, you can go after that. But I assume that it is not the case of any negligence on the CFS. It is more of the case of something happening on the reefer container, so to say, during the voyage. So if that is the case, I don't think, carrier can turn back and say, listen, you actually used the CFS, they are at fault. You have given me a bill of lading showing the temperature, set temperature is -18. You are meant to maintain the temperature during the voyage. You didn't maintain it. That's how I would approach it. So I think, I leave it at that, and I'm happy to hand it over to Vishal to take it forward.
Thank you. So if I may just add a little bit to this. There is some difference in law between the contract of carriage and the bill of lading. And the common phrase we lawyers use to confuse everyone is to say that a bill of lading is not the contract of carriage. It is merely evidence that a contract of carriage exists. So in a given case, if you've given a detailed quotation listing out your terms and conditions, that is accepted, then that becomes your contract of carriage. When a bill of lading is issued, it might supplement that, it might override that. In this trade, it is complicated because the quotation is given by one person, a bill of lading is issued by another person. So you have two parallel contracts of carriage operating, so as to say. So this is a unique problem faced by this sort of trade. But my understanding would be that as far as the shipper is concerned, if he's got a quotation which involves stuffing, carriage, and then discharge, under the bill of lading, the line is only responsible for the carriage bit of it. If there is a problem with the stuffing of the container, which was entrusted to the forwarder, then conceivably the shipper would be able to go against the forwarder because that was the task which was entrusted to the forwarder. And in fact, an argument may be run to say that the line is not responsible because that is a pre-shipment stage. The line was not involved with the shipping, with the stuffing. The line was only came into the picture once the container duly stuffed was handed over to it for carriage. So I would think, yes, conceivably the forwarder would be liable if it can be pointed out that there was a problem with the stuffing of the container, which has led to the deterioration of the cargo.
Can I say something?
Sure.
Suppose, for example, if as a forwarder, they have the survey of the container at the time when it was stuffed. That means whether the container was pre-plugged, what was the temperature at the time of stuffing. Obviously, they have to have 10 degrees minus before the required temperature levels, 10 to 15 degrees minus, so that after the stuffing, the temperature is maintained. And when the chart of the container, it clearly stipulates at what level it is plugged and what temperatures have been achieved all throughout. If the CFS is not able in a position to prove or substantiate with the proof of the chart, then I think the CFS can be held responsible by the forwarder, and the forwarder can come out of this claim.
So a question to the panelist, which again, as a forwarder, I would like to ask. In an event of a claim, on whom does the onus lie to prove the negligence? Just the shipper putting a simple claim, does it mean that as a forwarder, I have to prove my innocence? Or is it that the shipper has to first prove my negligence and thereafter the claim can be entertained? This is open to anybody to answer. If Mr. Jagan would like to start.
Okay, under English law, this I believe the House of Lords case, as far as English law is concerned, if it's a bill of lading contract, then the burden of proof would be on the carrier to prove that he was not negligent. That would be this thing. But on a contractual basis, then you would need to say, listen, the person who's claiming has to prove as the burden of proof. Now, there are issues, there are contracts, there's a bill of lading contract, there might be other contracts. So what I think the right way is, when you have a claim like this, you would have a joint survey, which in a joint survey, there are two things which are done. One is extent of loss and the cause of loss. Cause and extent of the loss are the two important things. So when you look at cause, you will be able to ascertain what was the cause, and then you will be able to find out who was responsible for it, who's liable for it. So when you have a loss like this, it is very important to have a good surveyor, especially on the liability side. A cargo surveyor does not have, I'm not trying to demean anybody, because in a cargo survey, it is much more important to find the extent of loss if the policy engages in pay. In a liability policy, you need a surveyor to have that bent frame of mind to find out who could be at fault, to try and defend it or deny the claim. So that is very critical for you to get someone to look at the part load chart. When did the temperature outage was there? What was the temperature at time of loading? I can tell you so many things on reefer. Reefer containers are not meant to cool the cargo. The cargo should be already pre-cooled. So when you load the cargo, it is not meant that you load cargo and expect the reefer temperature to decrease the temperature. It actually puts a lot of pressure on the condensers and the machinery, and the machinery can get spoiled. I've seen a lot of claims on this aspect. So, has it been done? Has there been proper spacing done? The vents have to allow the air to go in. Have there, there's so many things which are involved. So you need to really get someone to look at it, find out who's at fault, whose responsibility is, and then you deal with it. Now, irrespective, even if you are at fault as a forwarder, the liability policy is meant to defend you, assist you, as long it was, it happened by chance. Yes, when you drive a car, 99% you will not have an accident, but sometimes you do have accidents, and that is why you take insurance. The same way as a liability policy. It is very nice if you don't have any accidents or you don't have any claims, but if you do have a claim, if you have a proper policy, they will look after your interests. So, irrespective whether you're at fault or not, there is something to take care of your claim. I hope that answers your part.
Yes, it does. So can I just quickly summarize on this particular point is that number one, as a forwarder, be it a perishable cargo or a general cargo, that is a reefer or a standard container, as Mr. Makran suggested, we should have an SOP in place to have a independent surveyor company present at the time of receipt of the cargo and stuffing of the cargo as a documentary proof. We should, as forwarders, have a separate liability insurance policies to protect ourselves in the eventuality of any claim. And whether our fault or not our fault or lapse in the standard operating procedures, the liability insurance does come to our defense. And the third point would be, yes, the burden of proof principally would lie on the shipper to a larger extent. Of course, there is no black and white answer to this, but to a larger extent, the burden of proof does lie on the shipper. Can we summarize it in this manner before we move to the next point?
I think that would be a fair summary.
Okay, great. So I'll move to the next point now. So another commonly faced issue or a concern that we have is that in case of damages to the cargo, shipper or consignee insists on the issuance of a damage certificate as it is required by the insurance companies of shipper or consignee for processing claims. Will the issuance of such a damage certificate result in admission of claim Liability insurance policies have a clause that if we admit any claim in whatsoever manner, the claim with our insurance companies becomes inadmissible. I would like to start this particular point with Mr. Jagan, given his experience with insurance companies and law put together, followed by Mr. Vishal, and then Mr. Shantanu, and then Mr. Makrand.
Okay, thank you for the question. It's pretty interesting. I think the way I would look at it is, when you get damaged cargo or damaged containers, or you generally have an exchange of receipt known as EIR, showing the status, if this cargo is damaged. That should suffice for the claim, so to say. In my, experience as a claims handler, I would not recommend any carrier give a separate damage certificate. I would only say, listen, at the time of delivery, whatever is there, only that I will give. Because by chance, if you are delivering, let's say, at the terminal, they find there's some damage to the container. The EIR will mark that the right fender or right side container is damaged, cargo seeing out, or there's a leak. So that will mark there. In the case of console, you might find cut and stone. So at the time when you take delivery, it will be marked in your delivery order. I think if you have a claim, you look from that perspective. Now, giving a damage receipt is not admission of liability. There are two different things. Admission of liability is saying, yes, I am liable for the loss. Giving a damage receipt is basically factual. It is not saying, you're not saying something else. And it is generally given by third parties like a terminal, or even if you go to a stevedore, you'll give it. So I don't see anything on this, but issuing a separate damage certificate, I would not recommend it. I would probably, I'm always dealing on behalf of the carriers. I'm more combative on them. So I will try to, give as less as possible. But anyway, that's instinctive. Anyway, I leave it to others to take it forward.
Yes, Mr. Shantanu, would you like to start?
Well, somehow I have not faced this issue often. Normally, the way we have been able to defend this is by issuing the survey certificate. It is damaged, sometimes it is shortage. Every time, if it is a CFS stuffing, we have always issued a surveyor's report rather than us issuing a damage certificate. I think that's how I have dealt with it. I didn't have an issue where, because of the certificate issued by surveyor, we have been held liable. I have limited experience of this. We have refused to give, and we have insisted that surveyor is the right stakeholder to issue this certificate.
Mr. Makrand?
Absolutely right. We issue a survey report where the cartons are damaged or whatever. If they further insist, then we say you better take a joint survey. Let us conduct a joint survey, estimate what the loss is, and then you take the delivery.
Mr. Vishal, can you recap on this point so we can
so
move to the
just
next
recap. Everybody is right. One is issuance of a certificate of this nature is not an admission of liability because you're not promising to pay any amount. You're just saying that damage has occurred. That said, you should never issue such a certificate. We should always recommend that a survey be conducted and the survey report speaks for itself. So that's the way I would advise my clients. Do not issue such a certificate, though it's not an admission of liability.
And just a small deviation that in case if it is a factory stuffed container, so which primarily means stuffing responsibility was that of the shipper entirely, can we simply put a response to the shipper that, look, this was a shipper's load store and count stuffed by you in your premises under your supervision, and therefore the question of providing a survey report does not arise, and we under no circumstances are to be held responsible. Can we pass such statements as forward as?
No,
Mr.
not
Makrand?
really. Sorry, if I may just, not
Yes.
really, because it's a survey. I mean, anybody can survey it. You can't stop somebody from surveying the cargo if there's damage. The fact that it's a shipper stuffed container only will shift the burden of proof to the shipper to show that when he stuffed the cargo, it wasn't damaged. But it's not something that you can prevent a survey being done saying it's a shipper stuffed container, so I won't participate in a survey, or I won't allow you to do a survey.
Yes, Mr.
I
Makrand?
think if I may just, to make it a bit more interesting, let's take a forwarder, is involved in trucking the container to the shipper's premises. The stuffing is done by the shipper. And during the trucking, there is an accident. perhaps, to ensure that no one knows the container is patched up and it continues to the voyage. And no one notices the damage at the destination, they find there's damage. So, I think you need to look at the facts, so to say. During the voyage where the forwarder was involved in the transportation, he engaged the transporter. Might be he's doing it himself. So you need to look at what link, where the damage happened, even as a shipper's mistake. But yes, if everything is okay, if you are not able to find evidence of any accident or any incident during the voyage, the seals are intact, then obviously you could, like I said, you can desist, or you can say, listen, I don't want to attend. But it is better to be safe than sorry. I would still recommend that, a survey cost doesn't cost more than $400 to $500 internationally. So, you might stare at a claim of 100,000 or 200,000. It is better to be safe than sorry. So spend that 500,000, because you can ascertain what the loss is, what is the extent of loss. You can try to mitigate the loss, assist the cargo interest on a mitigation of loss, and also find out who's at fault. So that's the way I would probably look at it.
But I think one moot point, Vishal and Jagan, that comes here is, as a forwarder or as a multimodal transport operator or as a custom broker, particularly as a multimodal transport operator, are we obliged to issue a damage certificate to a customer because their insurance companies are insisting for it? I believe it is a role of a surveyor. It's a third-party surveyor we are appointing, an independent agency. And once we give that certificate, that should be sufficient.
Yes,
Yes,
Mr. Makran, do you have any inputs?
No, from this thing, we don't issue damage certificate. I mentioned it earlier also, and we would not go on to issue damage certificate. Survey reports should hold good for his insurance. I mean, we have sometimes been also contacting the insurance companies and asking them, because insurance companies are trying to make their life easier by asking for it. When they are going to file the claim against the carrier or, our principals, they want to make things easier for them. And that is the reason they insist, or they ask it from the consignees or whoever, but it is not a must. Survey report should suffice.
And just a leading question to the same point, somebody has asked is that if for any reason a joint survey has been asked, the shipper may ask the forwarder to assist in appointing a surveyor company for a joint survey. In such a scenario, A, does the forwarder take on any liability if he is appointing a survey company for joint survey? And B, whether any liability or not, should the forwarder be a signatory to the joint survey report, or it's purely between the surveying company and the carrier or the entity who is carrying out the carriage of goods? So these are two questions. One is, do we take a liability if we appoint a surveyor on behalf of the shipper? And second is, should we be a signatory to the document?
I think very fact the shipper is asking us, shipper or consignee, whosoever, is asking us to appoint a surveyor. There is no question of us being signatory, because he is not asking us to survey, he is asking us to appoint a surveyor. So I would like Vishal and Jagan to address whether, see, if there is a commercial pressure by shipper or consignee, then this is much beyond any liability insurance or any insurance claim. Commercially, we settle things which are never part of the legal liability. But coming to the legal aspect of it, how can an insurance company force us to issue damage certificate? Under what provisions? I think Vishal and Jagan can address that.
After you, sir.
Okay, you generally find this happening in when there is a movement from one location to another location, and there's transshipment, let's say in Singapore or Hong Kong, and there is damage, and you want a surveyor to do it. If a forwarder is requested or asked by his client to instruct a surveyor, there is a duty of the forwarder. He's acting as an agent to use a completed surveyor, and as long as he has done that, his role is over. Irrespective of the fact that the surveyor is done his job poorly, as long as he has done his, he actually analyzed or he looked at the market, who are the competent surveyors, and he does his bit. there can be no liability attaching to the forwarder. That's the way I would look at it. Insofar as signing the survey report is concerned, the survey report is signed by the parties who are attending or participating in it. Why should the forwarder, sign the survey report when, he engages the survey? I would not probably do it. I would probably ask, there is a survey to do it. He is more qualified to do it, and let him do it, and you just step behind. And you have to understand that the forwarder is acting as an agent, so that you should know his role, and let the forwarder, let the surveyor deal with the client. Or it might be through the survey, the forwarder. It doesn't make a difference. That's the way I would probably deal with it. Thank you.
Yes, Vishal, do you have anything to add?
No, I think that about sums it up. The forwarder cannot be liable because he's appointed a surveyor, unless he's appointed a surveyor who's no good at his job. And secondly is the surveyor signs the survey report. At the most, in the narration of the facts, he might mention that so-and-so people were present during the survey. But that again does not add a liability to the forwarder. So I don't think the forwarder will be worse off by nominating a surveyor at the behest of the shipper.
Okay.
So, Vishal, my question is, can the customer, be it consignee or shipper, force a forwarder legally to issue a damage certificate?
The simple answer is no, but they will do it commercially if they are a big customer.
Okay.
Okay. I will move to the next question. A consolidator ships a container to Canada. Upon destuffing, some packages have fungal infections. Canada Customs orders the return of container to the origin. Costs for return are approximately 10 lakhs plus. Question is, what steps should the consolidator take to protect himself or herself? What recourse is available to the consolidator? I would request Mr. Makran to start with this, but to answer it in two parts. One is, in case if the document issued is an MTD, and the second is if it is issued under the Indian COGSA, that's something like a CTD or a bill of lading, as both of them have different liabilities. So, Mr. Makran, if you could start.
Yeah. See, we have personally faced these claims twice. Okay. And the biggest problem is not of any other thing, but the biggest problem is losing customers. So I would say it goes on to a commercial thing always. So the easiest thing is when we get information from our agents that this container, they have asked to return it. We ask them to do a survey, because in most of the cases, these companies, they do not give the exact cause of the return. That means which packages are infected. They just say the authorities, the quarantine authorities have opened the package and they have said that this container cannot be destuffed. After this first incidents, then we got agreement with our agents that henceforth they would do the inspection in such a manner that they will pinpoint the responsibility or the package which is there. Now once the package is identified, if the value of the cargo is more, it is easier to get the cargo, easier to get the cost of all these things. If the value of the cargo is less, then it becomes a very difficult thing to recover. Then in that case, we play a little dirty game. We say the things are not being able to pinpoint which is the cargo which is, has infection. And then we try to put majority of the claim onto the package holder and then distribute the claim, other part of the cost, to the other shippers on that bill of lading. But it is a very troublesome process. This process takes about 3 months by the time you come out of it, and you have at least 4 to 5 unhappy customers in your hand who would never want to ship cargoes with you. So this is my very practical answer. Insurance companies come up with so many things that you don't get anything out of it. Because if we try to put per package or per shipment claim, because the claims are handled in that particular manner, it's a per shipment claim, and then 2,500 is deductible and you already have 10 shipments, so you get nothing out of it from the insurance companies who safeguard us. So this is the only way. I do not know right or wrong, but I believe there are a lot of consolidators who are attending this, and everybody would have gone through this. At least I know about 6 or 7 consolidators who have faced and have further gone to terminate the service for Canada, consolidation. And now I think there are only 3 people who are regularly doing Canada boxes. So this is the actual practical.
Makarand is frozen.
I think yes, Mr. Makarand's internet
on his
connection.
side is not good. So, yeah.
Yes, Mr. Makarand. Sorry, in between we had lost your internet connection, I think.
So I don't know where you lost me. If you can just.
You had said that most of the shipping lines or consolidators have stopped service to Canada, and there are barely 3 to 4 who are now serving Canada.
Yeah. So this is the actual scenario today, and people. The other thing, what we can do is we ensure that there are a lot of people who, as Mr. Shantanu has always been saying, paper insurances and all those kind of things. Those are paper fumigators, I would call. These paper people issue those fumigation certificates of the cargoes, but actually that fumigation is substandard. So we have decided that we get a proper fumigator, and these certificates are only acceptable for fumigation, and these people don't do any hanky-panky business. So most of the things, now we can say that our shipments into Canada in the last 3 years, we have not gone through it. But 3 years back, yes, we really worked very hard on it, how to get these instances reduced. And today we can say that we hardly have any instances of this kind.
Mr. Shantanu, would you like to add something?
Well, as Makarand said, this is a customer relation nightmare more than anything. And we face similar situations for FCL. It is not just for LCL. The cargo reaches destination with water in it, and quite often it is a watertight container, so shipping line would refuse. Essentially, then we have to really probe repeatedly and show that the wood they are using actually is releasing humidity. And no matter what treatment they give, and for machinery cargo, this is a regular problem. It is packed in solid wood, heavy machinery cargo, and Indian wood often releases humidity in the sea voyage once it reaches the destination. So I think here is what Jagan said, the role of a good surveyor at the destination is important. At our own cost, we have to appoint a very good surveyor. And luckily, in some cases, we saw where the machinery was wrapped very nicely in plastic, still it had humidity and water in it. So we could essentially insist with the customers that you have packing which is releasing the humidity, and that's why there is a water. And I think another thing what Makarand said applies across everything. We should stop having paper fumigation companies. We should insist customers stop having paper fumigation companies and paper insurance. And considering the costs that are involved, I don't know how we will do it, but if customer has a paper insurance, which is absolutely a no insurance, we should stop that business, because that shows attitude of a customer And eventually we are going to land in this position. And I think this is one clause we will work on inclusion in our contract, that they have taken adequate and comprehensive cover. Now this term will never be defined, but we will still try to define it in one way or other. I think this is the way to deal with such situations.
Mr. Jagan, a question for you is that in such a scenario, the fact that it is a fungal infection and which is to a large extent the fault of the shipper, can the forwarder put a counterclaim on the shipper that due to his poor packing or inadequate steps taken by them, the container has incurred cost and other cargo has also been held up? Can a forwarder put a counterclaim onto the shipper?
Okay, I would assume that the forwarder has issued his own bills of lading. If the forwarder has issued his own bills of lading, he becomes a carrier. Yes, he has a contract. I know India has not implemented COXA 1992. They are still on Bills of Lading Act 1855, if I'm not wrong. But irrespective of that, there is provision under the law that the original parties to the contract remain liable throughout for the fulfillment of the contract. The original party being the shipper. If the shipper has loaded a cargo, he should ensure it is done properly. Now, this question was more of a consolidation. I see where that's the way I could if it's let's say it was a consolidated container, I would assume that there would be many cargos, and which have been consolidated, and I'd assume that one or two or one of the cargos would be the negligent cargo, so to say, in the sense they have not done the fumigation or the wood has not been treated. The issue would be is whether the consolidator has provisions to check whether he has standard operating procedures to check that the wood has been treated. He has got certificates, especially for countries like Canada and Australia, which have much higher, stricter provisions, or fumigation is done. If it is a paper one and if the insurer comes to know, I think the insurer will be well within his rights to say it is a certainty instead of being a fortuity. So you may have an issue of cover there. But if the forwarder has done his job and if something goes wrong, the policy would kick in to respond with it. Now, Mr. Pradhan did say that the insurance company is talking of deductible per cargo. My understanding is it is any one incident or occurrence, AIOO. So that means if the damage to cargo in the container, or even if you have 10 containers in the same voyage and the damage is from a common incident, there will be only one deductible applicable. Perhaps you would need to get someone, not me, someone else, to guide you on that, because these are very technical aspects to see how can maneuver yourself to do it, or you need to go to your broker. Now, insofar as the insurance policy is concerned, I think I am not trying to sell any insurance. I think it all depends on what you want. I think you need to have a relationship with a company where you need to build it. And if you look at it as a partnership, they will work together to deal with your liabilities. Ultimately, what happens is it's a long-term relation, just like going to a doctor. You cannot keep on changing your doctor because someone else is quoting you lower. You need to have even a lawyer for that matter. I'm not trying to sell the services. It's a long-term relationship where they understand your business, where they can look at to help you. And obviously, if the insurance paper, the policy of no use, then people will not come to you. So I think I'm rambling around, but this is what I had the comments after Mr. Pradhan's talk on this thing. So I think as far as going after the shipper is concerned, yes, if you know who it is, you should go after. Unfortunately, India is a very difficult jurisdiction to pursue, given the speed with which the courts work with. And that is where I come to my pet theory. Perhaps it is time to consider arbitration. Arbitration is certainly faster. But if you go to courts, I'm involved in a matter in the high courts, which has not seen the light of the day. We've not even got the first hearing, so to say, for more than 1.5 years to 2 years. So I think my grandson or my children will perhaps be involved in that. But that's the sad part of it. So this is the issue which is there. We need to deal with it. Does that answer your question?
Yes.
For sake of clarity, paper insurance is not forwarder's liability insurance. Paper insurance is the customers are taking marine insurance, which is a paper insurance.
Okay, I think I clarify. If you look at the cargo insurance, it does not cover liability. it only covers ICC A, B, and C. It only covers risk of loss of or damage to cargo. It does not cover liability. Unless in their policy schedule they agree, which very rarely they do, they agree, no insurers are going to take the liability aspects. So you would find that there is a gap. Even in your forwarders or your liability policy you take, everything is not covered. There are some gaps. So you need to understand what the gaps are. Everything is not possible to be covered.
Mr. Vishal, if you would like to comment as a closure, and also quickly brief us on the liability of a forwarder if they have issued an MTD document, and liability in the case of a CTD document. If based on everybody's inputs, you could recap.
Well, so the interesting thing is that under Indian law there is no concept of a CTD document. I understand that is what the trade does, but Indian law only recognizes an MTD under the Multimodal Transport of Goods Act or a bill of lading under the COGSA. Now, a CTD is issued by way of practice because you have lines who don't want to register as multimodal transport operators but want to perform multimodal transport operations. So really the CTD terms, if you look at them, they're identical or virtually identical to the bill of lading terms. So which will basically make it impossible to hold the line liable because they have every possible disclaimer. As far as the MTD goes, if you issue an MTD, then you're under the Multimodal Transport of Goods Act. So then you have exemptions, you have responsibilities. So it will depend on the facts of each case. But in a case like this, where there's fungal infestation, etc., I would think that one of the common defenses the line or the multimodal transport operator would take, whether they've issued an MTD or a CTD, is inherent risk or inherent vice of the cargo. That this is a cargo which sweats, so this is a cargo which is prone to such fungal infections, and in which case the forwarder or the line would be exonerated from liability. So otherwise, I think we've pretty much covered every other aspect as far as this trade is concerned.
I think, Vishal, I may like to add, whether CTD is issued or bill of lading is issued, if it is multimodal transport, irrespective of which document is issued, the Multimodal Transport Act will apply and the liability regime of multimodal transport will apply.
Well, the difficulty with that is under the Multimodal Transport Act, it's only a registered multimodal transport operator who can issue a multimodal transport document. And only when a registered multimodal transport operator issues an MTD that the act kicks in. So then you're left with this blank area where someone like, say, a line which does not have an MTD license issues a CTD, does an MTD trade, but neither the COGSA nor the MTD is applicable. Now, this is an interesting issue. It's never been judicially tested, but I think at some point in time, someone will decide to carry it. And if that happens, I do agree with you, Shantanu. I think the view that will be taken is that you've done it at your own peril. So we are going to impose all the liabilities of the MTD on you, but we are not going to give you any of the exemptions because you didn't register. I think that's the price you will pay for not registering and doing an MTD trade.
Then probably, Vishal, will you say the liability will be absolute? The limitations of liability under COGSA or limitation of liability under Multimodal Transport Act, neither of them will apply, then the liability will be absolute.
Because you're doing something illegal.
Yes.
You're doing so, then you can't claim, you can't say I will do something that the law doesn't allow me to do, but you give me the exemptions in law.
So I mean, the liability would be absolute.
Yes. So that is, I mean, that's how I would argue it. Again, it's not been judicially tested, but that's how I would argue it.
Okay, great. So I'll move to the next point now. An MTO or a consolidator erroneously puts the incorrect container number in the bill of lading or the MTD document. The cargo is safe but confiscated by the customs at destination. What is the liability of an MTO document if it is issued? And what is the liability of a forwarder if they choose to issue a bill of lading or a CTD under the Hague-Visby or similar rules as defined on the reverse side of the document? So can we start with Mr. Jagan on this?
Yeah, I think you need to find out who's at fault. I think if the MTO consolidator erroneously puts a container numbers, I would assume that the bill of lading draft was also sent to the shipper. You know, generally I look from the liability side, I would probably try to argue that there is also a liability on the part of the shipper not checking the BL. In the case of a consolidation container, it is not possible because it is the loose cargo is given. If it's a full container, the shipper would know what is the container number. Now, the question is, yes, the same consolidator can use the same argument by going after the actual carrier, but in this case, it is his BL. So for whatever reasons, there is a discrepancy in the documents. There is a fault on the consolidator. Cargo is confiscated. And therefore, the consolidator would have to deal with the claim. There is one difference between an MTO and a CTD or a bill of lading is a time bar. I don't think insofar as the limitation of liability or the exclusions of liability, there is any major difference. Insofar as an MTO, multimodal transport, BL, provided is a multimodal transport, it provides a 9 months time bar, which is pretty short by the time the cargo insurers pay. And if they are trying to found jurisdiction in India, you may have a defense saying that the claim is time barred. But in other jurisdictions, I do not know whether they would accept, because I don't know. It's yet to be judicially tested, so to say. In the case of Hague-Visby rules, it's 1 year, so you have an additional 3 months, which is there. I think in this type of case, it is important. What can you do? You need to have a good agent who will probably guide you to deal with the issue, to talk to customs, to pay the penalties, to try and move it out. If not, you need to, deal with the cargo claim, and that's where your liability policy would assist. They would generally not pay the full value. It will be on the basis of limitation of liability. So this is a classic example of how a policy could assist a consolidator when something goes wrong. But the consolidator would need to prove to the insurer that this was an isolated error. It was not due to that their staff did not have proper training, or they did not have SOPs to check the container, or they were overworked, or they don't want to have this thing. So these are, if you tick the check boxes, if you have done everything else, and it just so happened it was an error, your policy should assist you in dealing with the claim. Thank you.
Before I move to the next point, does anybody have any input?
Yeah, I would say the case you are referring to my mind, is an aberration rather than something which happens persistently.
Hope so.
Agreed.
The containers don't get confiscated just by erroneous container number. The destination agents normally are able to correct, or we are able to correct it and amend it and send. Yes, there are some countries where it can be little bit more difficult than other countries. For example, Brazil and Mexico, sometimes such things. Argentina, for example, it can be little bit difficult. In most other countries, these are treated as routine amendments, unless there is some other challenge attached to it. Means, in addition to container number being wrong, there is something that is problematic with the cargo that can result into confiscation, is a different story altogether. Normally, in some countries, I don't want to name them, the destination agents try to exploit the situation to make money out of it. But I would still say this is an aberration and not a routine occurrence. And I don't believe either of the claim settlers or lawyers would be getting such cases quite often, or hardly ever any case they would get.
Great. Can I move to the next question with the permission of the panelists?
Yeah.
Thank you. The next case study is consignee returns the empty import container after taking cargo delivery. At the time of empty return, the carrier informs the forwarder MTO that the container is found damaged upon return to the yard. Is the forwarder, consolidator, or MTO responsible, and can they recover from the shipper or the consignee? Again, if we could answer this question from an MTD document perspective and from a bill of lading perspective. So, because this is a very, very common occurrence in majority of the forwarders' day-to-day transactions. So, can I request Mr. Shantanu to first start with this point?
I think here essentially we have to see if the multimodal transport operator has a door-to-door contract. if they have a door-to-door contract, obviously they are liable because the importer in this case doesn't have any role. So there is no escape for a multimodal transport operator. And whether it is CTD or MTD, I don't see any difference in this because you have a door-to-door liability. Whereas if the contract of carriage terminates at the port CY or port CFS or even hinterland, say ICD Tughlakabad, and the onward move is done by the consignee, then obviously the contract of carriage has terminated over there. And then the transaction will be between the owner of the container or which is NVOCC or shipping line and the importer and custom broker, not really the transport operator over here as MTO or as a combined transport operator.
I'd just like to expand a small point over here, the word damage. One is an external damage and internal damage. Now, an external damage, I can understand if it is a door-to-door, the external damage probably would be more on account of the forwarder. But in a scenario of an internal damage, if it is a door-to-door, the container, the responsibility is to deliver it to the door, but destuffing continues to be the responsibility of the consignee. How do we deal with such a situation?
The reality of life in such cases is might is right. And we have seen shipping lines and we have documented cases of shipping lines when India is the exporting country and there is damage to the container on dropping off at a foreign destination and European and American destinations, they hold Indian exporter liable for damage. When India is the importing country, they hold the Indian importer as a liable party over there because of you have carried container, and in those countries their logic is because of the way you have stuffed the container, it has led to damage. Because shipping lines are aware they can't play too much mischief with the importers or exporter in those countries. It is a might is right issue. Same with our relationship with our customer. See, whether the customer is liable or we are liable is a matter between us and the customer. Insofar as shipping line is concerned, if it is a door-to-door contract, it is your liability because you have carried the cargo up to that particular location under your contract and not at the behest of the consignee. So if consignee has damaged, it is between us and consignee to settle the issue. It is not a case of whether the consignee is liable to the shipping line for damage or whether the forwarder, which is MTO or CTD, who is liable for it. I think that's my understanding of this case.
Mr. Makran, do you have any inputs?
Yeah, it is more or less the same. There is no one right answer to this, and as Mr. Shantanu has mentioned, that might is right is the only way, and what your relationship with the shipper and the consignee is. How we protect our interests as far as consolidation containers is what I can tell you. And when we are stuffing the containers. We are taking photographs of each and every row and the package covered, and then we can be very sure about what we have stuffed. So any of our agents coming back with it, we can immediately justify that this is not from my side and this is why destuffing the container and you better pay for it. And those are the contracts that you have to make while you have contracts with our agents. In the contracts, normally what we have is terms of settlement, terms of termination, and what is the profit share and all those things. But if we have a foolproof contract which takes into consideration all the scenarios, then I think we have a decent safeguard. When we are doing even FCLs, at the time of releasing the containers, we are surveying it and taking a equipment interchange receipt, and that acts as a proof that the container when sent was in so and so condition. So anybody claiming on that, we have a proof, we have a record, we attach it to the job and send it, and that's how we can safeguard our interest if we have not made a mistake or our agent has not made a mistake. But these cases, majority of the time, are on the basis of commercial decisions, because internal damages are not so expensive for the container. It's the plywood damages, basically the floor damages. That is what comes through in consolidation containers.
Mr. Jagan and Mr. Vishal, would you all would like to comment on anything on this, or can we move to the
Yeah,
next?
I would echo what Mr. Pradhan said. I think what do you say? A consolidator or a forwarder who wants to safeguard his position will take pictures of before and after, at the time when he got the container, at the time when he's returning, to ensure that he's giving the same condition. The costs of electronic pictures have gone down drastically, so it's not a problem. Even your mobile phones can take that. Just a small point, in so far as MTD document, I believe this is an import shipment. My view is the MTGA only applies for export-oriented shipments. Although you could perhaps argue if the the MTD documents provides for Indian law and jurisdiction, the MTD would apply. But what would happen is there would be a conflict of law situation, because you would have some other laws from the outward shipment. So, but since we're talking to the Indian perspective, it may well be that the courts hold that the MTD applies because the MTD has been issued. But there is a gray area on that. Other than that, it's a similar this thing. It doesn't make a difference whether it's an MTD or this thing. I think if COXA 1992 is more explicit, the person who takes delivery of the cargo is responsible to give it in the same way. India has not implemented COXA 1992. So you would need to try and establish the same thing. And it doesn't make a difference. You actually, the only advantage you could probably say, the consignant could say, I can only take the benefits of the contract. I don't need to take the burdens of the contract. COXA 1992 changes that. I think Mr. Vishal would probably add on that aspect. But having said that, yes, if you take pictures, you're able to show that there is no fault, there is no damage, you are able to deny it. And if by chance there is actually a damage, you can pursue it on down the chain against the consignee who may have caused the damage. Thank you.
Mr. Vishal, any inputs from your end?
I think that pretty much sums it up. There's just one additional point is, in most cases when the containers are being taken from the CFS for factory destuffing by the consignee usually executes a bond or an indemnity which says that the consignee will be liable in case of any damage, this, that, the other. So that is another precaution which the MTO or the CFS could take, saying that, listen, you've issued this bond, so you're liable for any damage. But apart from merely issuing the bond, yes, it makes sense to get photographs, because that will prove that the container was given in a particular condition and received back in a particular condition. And that is eventually what your claim will turn on.
And I would like to add here that apart from the bond, the shipping line also insists on taking an empty container insurance policy, for every container, and only then they issue the delivery order. That is in case of imports. And in case of exports, when we as a MTO undertake a door-to-door move, and we are basically, doing a door-to-door move from, let's say, India to the US, we can also take an empty container export, cover from any insurance company, which is available. And insurance companies do, process such claims, and we have experienced that. That's what, I've come across.
Possibly that's a practical solution.
Yes.
Amit, the cover which you talk is equipment cover, but there would be a deductible. I assume that about 1,500 any one incident. So if it's below 1,500, you need to bear it yourself. That's what my understanding is.
I have had a different experience. So we have taken covers, for the reefer containers that we do, and we are very, scared ourselves when we do a lot of reefer containers, because the equipments are very, very expensive. So the minimum deductibles are very, very small, and it does, make sense to take that kind of a cover. Yeah.
Okay, great. I'll move to the next point.
And
So
maybe we wind up in next 5 minutes. I think or 10 minutes. I think let's give time.
Okay, so if we would like to wind up, then can I quickly run through some of the questions that have been put
Because
by the
it's
attendees?
already 1 hour 55 minutes, so maybe we have to have.
Yes.
Okay, so I will just quickly try and run some questions which have been put by the attendees. So one of the question put by Mr. Rahul Verma is that, is a container a packaging also as per ICCA 4.3? Is a container considered as a package?
I've already responded to this thing. In my view, no. A package is an independent. What happens is you look at the bill of lading. The question is, when you look at the cargo policy, they want to ensure that the cargo is properly packed. So you cannot say, oh, I put the cargo in the container, it's been properly packed. So you need to look at what is the basis of what you're going. So the cargo policy, no, it has been properly lashed, stored, or in a carton or in a pallet or whatever it is, not the container. Because the container is only an outer covering as far as the cargo is concerned.
Okay, a quick question from Mr.
I
Vishal.
I think this answer depends on the context in which it has been asked. If it is a shipment to USA, and if your bill of lading says one container containing 35 packages, then the liability will be driven by 35 packages. Whereas if the bill of lading says just one container, then it will be one package liability of $500 that will be applicable. So I don't know in which context the question has been asked. So if it is per package liability, then a container, unless you declare set to contain so many packages, it will be one package.
Okay. Quick question from Mr. Vishal. This is by Mr. Darshan Sheth, that if the standard trading conditions are attached along with the quotations that are sent to the clients, and in the contract or the quotation itself, we mentioned that the STCs have been attached and the business is undertaken under the said enclosed STCs, would that suffice to protect the forwarder?
Well, that would certainly make it much better than just having a footnote saying subject to STD, because you're forwarding a physical document and you're saying that these are the terms and conditions on which I do business. So yes, that would make it much easier for you to then subsequently rely on your STCs. Not 100%, but as close to 100% as you can get without getting a written confirmation from the counterpart saying I accept your STCs.
Okay, and the last question that I will put up before giving the closure is by Mr. Prashant Popat, that what is the liability of a forwarder in case of unclaimed cargo at destination when on the master bill of lading, either our company in India or our counterpart is mentioned as a shipper or a consignee? So this is something that everybody faces practically on a daily basis. If Mr. Shantanu and Mr. Makrand, y'all can start, followed by Mr. Jagan and then Mr. Vishal to tell us as to how do we protect ourselves. Mr. Shantanu.
If you take my suggestion, we have kept a separate session for this particular topic along with other topics. It won't be a quick answer, and we have kept a separate session. So maybe Prashant attends our next session and you can take the next question if there is any.
Okay, great. So I would formally like to announce the closure of today's session since we are exceeded our time limit. I would like to thank Mr. Shantanu, Mr. Makrand, Mr. Vishal, Mr. Jagan to take your time out of your busy schedule, share your experiences, your knowledge, your wisdom with all of us. And we are hoping to continue with similar sessions with the balanced questions and points for time moving forward. Thank you very much. Mr. Amit, if you could give your vote of thanks.
I think before Amit, let me share one comment which I just briefly read in the pop-up screen. I think Mr. Saxena has said that he liked the approach of giving diverse views. So maybe this is an interesting way of dealing with complex topics which we are dealing. Rather than a monologue, we should have interactions amongst panelists giving diverse views. I think that's a comment I read here. Amit, back to you.
Vasant, please go ahead with the vote of thanks.
Friends, we have had a very informative session, and we agree that there are several other deliberations or opinions which may come up at the actual time of handling the issues practically, maybe.
Yes.
I, on behalf of AMTOI and CAI, would like to thank Jagan for sharing his valuable time and sharing his knowledge with all our members, which he's always available for us, and a great thanks to him. I'd like to thank Vishal Seth for giving his inputs on the legal aspects of the cases presented and discussed. And Mr. Vishal, we'll keep on bothering you again for our next sessions. So, our thanks to our President, Mr. Shantanu Badkamkar, and Mr. Makran Pradhan, President of CAI, for their valuable inputs and giving our members their insights from their valuable experiences. My sincere thanks to Mr. Amit Pendere, convener of Western Region, and Mr. Keyur Gandhi, who have really worked hard to compile the cases in consultation with Mr. Pakar Pradhan of CAI and other panelists. We thank all the participants for being a part of the webinar and look forward to their participation in the future knowledgeable sessions, which AMTOI will continue to host. Thank you once again and have a nice day.
Amit,
Thank
please
you